Hello, everyone, and welcome to Uncivil Law. For today's case, we have an update on a recent situation. A governor in Kentucky tried to ban people from going to church services for Easter, even including drive up church services. And we recently read the complaint filed in the district court. But today, we have a decision from the Court of Appeals. Yes, even though the original complaint happened on Easter, which just happened, we have a decision from the Court of Appeals in that case. When the courts really want to, sometimes they can ball. And that's what we did today. We have a decision from a Court of Appeals in a situation that's like 3 weeks old. So we're going to read this decision and figure out whether or not the governor of Kentucky, for reasons that pass understanding, can or is allowed to ban drive up church services. Let's get started with this. Maryville Baptist Church and its pastor, Dr. John Roberts, appealed the district court's order denying their emergency motion for a temporary restraining order. The church claims the district court effectively denied their motion for preliminary injunction to stop Governor Andy Beshear and other Commonwealth officials of the Commonwealth of Kentucky from enforcing and applying to COVID orders. The orders, according to the church, prohibits its members from gathering for drive-in and in-person worship services, regardless of whether or not they meet or exceed the social distancing and hygiene guidelines in place for permitted commercial and other non-religious activities. The church moves for an injunction pending appeal, while the Attorney General supports, as amicus curiae, the governor opposes this motion. So there you see one of the little quirks of state law that usually happens up. It is usually the case in many states that the governor, lieutenant governor, and the attorney general are elected separately. So, in the United States federal system, we used to elect the president and vice president separately, and then we kind of realized that was dumb. We don't do that anymore. And of course, the attorney general is appointed by the president, but not so in many of the states. In many of the states, the governor, lieutenant governor, which can be thought of roughly as vice president, and the attorney general are separately elected. So here you see the consequence of that decision. The governor of Kentucky opposes this, but the attorney general of Kentucky supports it because they were elected differently and they have different dispositions. So the governor can't give a direct order to the attorney general because they're a separately elected official in the Commonwealth of Kentucky, as is not uncommon in many of the states. So you see just that little bit of infighting between the upper levels of the state government. How fun. The governor of Kentucky issued two pertinent orders. The first order issued on March the 19th. So again, we're talking about things that are like 6 weeks old. I mean, tops, because we're talking about the orders, not even the incident underlying this, right? So everything's happened rapidly. The first order issued on March 19th prohibited all mass gatherings, including, but not limited to, community, civic, public, leisure, faith-based, or sporting events. It exempts normal operations at airports, bus and train stations, shopping malls and centers, which seems a little odd. It didn't exempt shopping malls and shopping centers. So we're going to prohibit people from going to church, but not from shopping. That seems a little odd, but okay, that's what the governor of Kentucky did. And also exempted typical office environments, factories, retail, or grocery stores where large numbers of people are present but maintain appropriate social distancing. I'm not sure how that works in shopping malls, but okay. The second order, issued on March 25th, required organizations that are not life-sustaining to close. According to the order, religious organizations are not life-sustaining, except when they function as charities by providing food, shelter, and social services. However, laundromats, account services, law firms, hardware stores, and many other entities count as life-saving. I don't, as high an opinion as I have the legal profession, I'm not sure how life-saving we necessarily are, but it's nice to be wanted, it's nice to be needed, and all these other places are apparently essential, but not churches. Okay, again, this is something the governor of Kentucky did for some reason. On April the 12th, Maryville Baptist Church held in a drive-in Easter service. The congregants parked their cars in the church's parking lot and listened to a sermon over a loudspeaker. The Kentucky State Police, because they have nothing better to do apparently, arrived in the parking lot and issued notices to the congregants that their attendance at the drive-in services amounted to a criminal act. This is just great. We got the State Police of Kentucky going to a church and saying, you can't meet, that's criminal. Super. The officers recorded the congregants' license plate numbers and sent letters to vehicle owners requiring them to self-quarantine for 14 days to be subject to further sanction. How not creepy or dystopian in any way. The church says these orders and enforcement actions violate the congregate rights under the Kentucky's Religious Freedom Restoration Act and the free exercise guarantee of the First and 14th Amendments to the Constitution. So I've talked about this a little bit before, but under the classic First Amendment doctrine, if you have a law of neutral applicability, it's generally okay. However, the federal government and many states have passed laws that go further than that. They're called Religious Freedom Restoration Acts. And they say even if it's neutral, you still have to meet strict scrutiny. So they go further than the Constitution would otherwise require. And so that is true in Kentucky too. They have a Religious Freedom Restoration Act. So even if it's neutrally applicable, if you're going to burden religion, you have to show a special showing. So that should be super fun. The church is likely to succeed on its state and federal claims, especially with respect to the ban for its applications to drive-in services, because, drive-in, not quite sure what the problem is, but all right. Start with a claim under the Commonwealth's law, the Kentucky's Religious Freedom Restoration Act, which says, quote, government shall not substantially burden a person's right to act in a manner motivated by sincerely held religious belief. It guarantees that unless the government proves by clear and convincing evidence that is used the least restrictive means to further a compelling governmental interest, it is infringing the act. So we see a couple wonderful legal trigger words that are also interesting. So not only does it have to be strict scrutiny, it also be shown by clear and convincing evidence, which is also higher than the normal rule. So like normally you just have to show a preponderance of the evidence, but you have to show preponderance of the evidence to what thing you're trying to prove, right? So you're trying to prove a compelling governmental interest and least restrictive means, and you normally have to show only preponderance of the evidence, and normally that's really, really hard. So not only did Kentucky say neutral applicability is no good, we want strict scrutiny. And not only do we want strict scrutiny, we want extra strict scrutiny. We want you to prove by clear and convincing evidence, not just preponderance of the evidence, that this is all necessary. So Kentucky, by its law, has made it really, really hard to discriminate against religious services. They are super, super serious about it in Kentucky. Apparently the governor's not super, super serious about it, but that's why they're getting smacked down. Application of this test requires little elaboration in most respects. Yeah, I mean, it's a pretty well-established test. These are standards we've been using forever and a day, so at least the courts understand them pretty well. The governor's actions substantially burden the congregants' rights to sincerely held religious practice, and plainly. It's on its face. Not a lot of deductive reasoning needed. It's plain. Religion motivates these worship services. Yeah. And no one disputes the church's sincerity. Orders prohibiting religious gatherings enforced by police officers telling congregants they violated criminal law and by the officers taking down plate numbers amounts to a significant burden on these gatherings. It sure does. It sure does. Let's just take names and addresses of people who attend services, and we'll put them on a list. And then we can treat those people that we have on those lists separately. Maybe we can put them onto railway cars and send them away to camps. That's never been a problem ever in the history of time. At the same time, the governor has a compelling interest in preventing the spread of a novel, highly contagious, and sometimes fatal virus. All except these conclusions. The sometimes fatality thing is somewhat still in dispute. How much sometimes fatal is still a little bit up in the air because it's unclear what the fatality rate is. But yeah, sometimes fatal, sure. The likelihood of success inquiry turns on whether the governor's orders were the least restrictive means of achieving these, and presumably also to the requisite clear and convincing evidence standard. This is a difficult hill to climb. It was never meant to be anything less. Yeah, strict scrutiny is really, really, really hard. It has been called strict in theory and fatal in practice because it's so really, really, really hard that most of the time you just can't get anywhere. It is just really hard to meet. Now, the current situation does make it a lot easier to meet that. So a lot of people have been upset that they feel like the Constitution has been suspended because of the current situation. Now, from a current legal theory framework, that's not true. It's just the facts are different. So the test that's normally basically impossible to meet has been made possible because of the novel situation. Now, that doesn't mean it can be met forever. It doesn't mean that it can be met indefinitely. It doesn't mean that as we learn more and more, these orders remain lawful. And we're starting to see those beginning to crumble, where states such as God's favorite state, the state of Texas, has begun to release things because as the facts become more apparent that this is no longer being maintained, the rationale for the action is undermined. And same thing here. It's like, this is meant to be really, really difficult because the burdens you're putting on people's fundamental rights are so important. It's like you can meet those in some respects, but not in every respect. And this is an example where the Kentucky government went too far. Even under the current situation, they went too far. Even knowing what they knew, they went too far. Because even knowing what they know, there was no basis to prevent people from going to church service if they're going to remain in their cars. So even that was too far. It didn't make sense under the facts. So that's, how you apply these frameworks using traditional constitutional analysis tools. The likelihood of success inquiry turns on whether the orders here were the least restrictive means. The way the orders treat comparable religious and non-religious activities suggests they do not amount to the least restrictive way of regulating the churches. Yeah, those words, least restrictive, carry a lot of weight. Even when you're trying to meet strict scrutiny, you want to do the very little you can do under the situation to deal with it and burn it to the least degree possible. And that's one thing, strict scrutiny. So not only does your need to be compelling, it needs to be done in the least restrictive way. And this wasn't the least restrictive way. And not by far. There's no basis for it here. So, yeah. The order permitted uninterrupted functioning of a typical office environment, which presumably includes a business meeting. How are in-person meetings with social distancing any different than a drive-in service with social distancing? Excellent question. One that doesn't really have an answer. And the very fact it doesn't have an answer is the reason why this doesn't work. So, there are constitutional rules here, even in novel situations. Kentucky permits the meetings and bans the services, even though open-air services would seem to present little health risk. Yeah. If you believe the numbers coming out of China, and, why should you? But they claim that, only 2 people were infected in open-air environments. So, to the extent you believe them, there's that. The orders likewise permit parking in parking lots with no limit on the number of cars or length of time they're there, so as long as they're not listening to a church service. That's very true. When you're going to go to the mall and social distance, it's fine. You can remain in your parking lot as long as you want. But if you're listening to church services, that's a no-go for some reason. On the same Easter Sunday, the police officers informed congregants they were violating criminal laws by staying in their parking lots. Hundreds of cars were parked in grocery store parking lots less than a mile from the church. Yeah. The orders permit big lot parking for secular purposes, just not religious purposes. Sounds problematic given what we know, right? All in all, the governor did not narrowly tailor the order's impact on religious exercise. Certainly sounds that way to me. Consistent with the governor's threat on Good Friday, state troopers came to the church Easter services, told congregants they were in violation of criminal law, and took down the license plate numbers of everyone there, whether they had participated in a drive-in or in in-person service. The governor's orders also likely prohibit the free exercise of religion in violation of the First and 14th Amendments, especially with respect to the drive-in services. Sounds that way. Discriminatory laws come in many forms. Outright bans on religious activity alone obviously count. So do general bans that cover religious activity when there are exemptions for comparable secular services. As a rule of thumb, the more exceptions to a prohibition, the less likely it will count as generally applicable non-discriminatory law. So there they're talking about the baseline constitutional standard, under federal First Amendment doctrine. So not under state law, but under federal law. And again, states can go further when it extends more rights. So under federal law, you can have a general neutral applicable law. So if the rule is, your general building codes or your general rules on how many spaces you need in a parking lot for how many people, those kinds of things. It doesn't matter if it's a church or not, right? So either way, it's the same rules for everybody. So if it's generally neutrally applicable, that's fine. However, the more exceptions that you make, if you start carving a whole bunch of things out, it suddenly starts becoming less generally applicable. So there's some point where you're putting things in and putting things out to such a degree that's no longer general. And so that wouldn't work. But they're just talking about the normal constitutional standard there. The real question goes beyond the exceptions. The government insists at the outset that there are no exceptions at all. But that is wordplay. The order allows life sustaining operations and doesn't include worship services in that definition. And many of the serial exceptions for secular activity pose comparable health threats to worship services. What those would be in the case of driving services, you can only speculate, because I don't know. For example, the exception for life sustaining businesses allows for law firms, laundromats, liquor stores, and gun shops to continue to operate so long as they follow social distancing and other health related precautions. It's nice to know Kentucky is at least allowing the Second Amendment to continue, even if they don't allow the First for some reason. But the orders do not permit soul sustaining groups, even if those groups adhere to all the public health guidelines required of essential services and even when they meet outdoors. Sure, the church might use Zoom services or the like, as so many places of worship have decided over the last 2 months. But who is to say that every member of a congregation has access to the necessary technology to make that work? Or to say that every member of a congregation may see it as an adequate substitute for what it means when 2 or 3 gather together in my name? Yeah, while they're all alternatives, again, we're looking to the least restrictive means. And so, people can choose to worship how they want. Now, some of those means might be able to be curtailed under current novel situation given strict scrutiny, but not necessarily all those means. And some are not necessarily substitutes for others. And why aren't you letting people meet in church parking lots? Who knows? But you're not. And, you can't do that. Keep in mind that the church and Dr. Roberts do not seek to insulate themselves from the Commonwealth's general public health guidelines. They simply wish to incorporate those guidelines into their worship services. They are willing to practice social distancing. They're willing to follow hygiene requirements. They're not asking to share a chalice. The governor has often no good reason so far for refusing to trust the congregants who promise to use care worship in just the same ways that it trusts accountants, lawyers, and laundromat workers to do the same. The fact that you're willing to trust church members less than lawyers is mildly hilarious. If any group fails, the governor's free to enforce those rulings against them for that reason. Yeah, so, if you can show that they are not obeying the guidelines, you might have a, as applied cause. But until then, you don't really have anything, so not so much. The governor claims, and the district court seems to think so, that the explanation for these two groups of people to be in the same area, the intentional worship, distinguishes them from groups of people in a parking lot, or a retail store, or an airport, or some other place where orders may be allowed to be. We doubt the reason a group of people go to one place has anything to do with it. Risk of contagion turns on social interaction in close quarters. The virus does not care why they are there. So long as that is the case, why do orders permit people who practice social distancing and good hygiene in one place but not another? Excellent questions. The balance is difficult when it comes to in-person services. Allowance for drive-in services this Sunday mitigates some harm to the congregants and the church. In view of the fast-moving pace of this litigation, and the view of lack of additional input from the district court, whether of a fact-finding dimension or not, we are inclined not to extend the injunction to in-service purposes at this point. We realize this falls short of everything the church has asked for and much of what it wants, but this is all we're comfortable doing after the 24 hours the plaintiff has given us in this case. So yeah, that's just how fast we're balling here. That's how fast we are dealing with this thing. We went from district court and we immediately appealed, and in less than a day, less than 24 hours, we have a decision from the Court of Appeal. You gotta love that service time, man. You gotta love that service time. Amazon Prime can't get you delivery that fast, But the Court of Appeals, man, they are there for you. That's awesome. In the near term, we urge the district court to prioritize resolution of these claims in view of the looming May the 20th date, and for the governor and plaintiffs to consider acceptable alternatives. Accordingly, the plaintiff's motion for an injunction pending appeal is granted in part. Signed, the Court of Appeals. So that is the decision from the Sixth Circuit Court of Appeals in the case of Maryville Baptist Church versus the governor of Kentucky. So yeah, we are just all kinds of responsiveness over here. The appeal was filed on May the 1st. We have a decision on May the 2nd to incidents that occurred like the week before, and now we're covering it on the 3rd. So we are all acting super, super fast in this ongoing matter because of the ongoing situation. I love it. And what we learned in this situation is the governor of Kentucky, for reasons that pass understanding, doesn't want people parking in a parking lot if the purpose for them doing so is to listen to a church service. If you want to park in a parking lot to go into a shopping mall or a business, that's totally fine. But if you want to sit in your car to listen to a church service, that goes too far. for some reason, and the Court of Appeal says this doesn't make any sense, and so they grant the injunctions. Like, no, no, you can't do that. No, that doesn't make any sense. They should be allowed to sit in their cars. So the people of the Maryville Baptist Church will now be allowed to sit in their cars and listen to services, and that police, who apparently wrote down their names like, narcs or something, will have to be very, very sad, I guess. And that is the end of our current coverage of this case. Thank you so much for being part of the Uncivil Law family. I appreciate your continued support. If you haven't already done so, please subscribe to this channel, and you can also support us financially by clicking the applaud button below. Thank you so much for your contributions to our channel. It helps our work grow. Until later, cheers and goodbye.